My childhood friend who I helped through cancer stole my business idea, patented it, and is now suing me for infringement. The process server handed me the manila envelope at 9:23 a.m. on a Thursday morning, and I actually smiled at him because I thought it was the prototype shipment from the manufacturer. I signed for it with my coffee still steaming on the porch railing, made some joke about early deliveries, and didn't open it until I got back to my desk. The header read, "Complaint for patent infringement," in bold letters across the top, and below it, in smaller print, Plaintiff, Derek Lansing, my childhood best friend, the guy whose hospital room I'd practically lived in for 6 months during his chemo, the guy who'd sobbed in my arms when they told him the cancer was gone, the guy I'd trusted with everything. I read the first page 3 times before my brain would accept what my eyes were seeing. He was suing me for stealing his invention. The invention I'd spent 2 years developing in my garage while he was getting well. The invention I'd told him about during those long hospital nights when I was trying to keep his spirits up. My invention. I'd known Derek since we were 7 years old, back when his family moved in 3 houses down, and we bonded over a shared obsession with building things. We weren't the sports kids or the popular kids. We were the ones taking apart our parents' electronics to see how they worked, the ones building elaborate Rube Goldberg machines in his basement, the ones who got excited about engineering camps in the summer. Through middle school, high school, college at different universities, but always staying in touch. We'd been brothers in everything but blood. When he got his diagnosis at 29, stage 3 lymphoma, I'd been the first person he called after his parents. I'd driven straight to his apartment, found him sitting on the floor of his bathroom, and held him while he cried. I'd promised him then that we'd get through it together. I'd meant it. Every chemotherapy appointment I could make, I was there. Every bad scan result, every terrifying doctor's visit, every 3 a.m. panic attack when the fear got too heavy. I was there. During those long nights at the hospital when the chemo left him too sick to sleep but too exhausted to do much else, we'd talk. He'd ask me about my life, my work, anything to distract himself from the poison dripping into his veins and the hair falling out in clumps. I was working as a mechanical engineer for a mid-sized manufacturing firm, but my real passion was the project I'd been developing in my spare time for about a year before his diagnosis. It was a modular solar panel mounting system, nothing revolutionary on the surface, but I'd figured out a way to make installation dramatically faster and cheaper using a unique bracket design that eliminated the need for roof penetration while actually improving wind resistance. The magic was in the interlocking mechanism and weight distribution. I'd been sketching iterations, building prototypes, testing them on my own roof. I'd even started the patent application process, had my initial drawings done, was working with a patent attorney named Douglas Reeves who specialized in mechanical inventions. I'd shown Derek my sketches during one of his overnight stays, week 14 of his treatment. He was having a bad reaction to the latest chemo cocktail, couldn't keep anything down, and the despair in his eyes was worse than the physical sickness. I'd pulled out my notebook, thinking maybe focusing on something else would help. I walked him through the whole design, the cam lock system, the load distribution math, the installation process that could cut setup time by 60%. His eyes had lit up for the first time in weeks. He'd asked smart questions, offered a few suggestions about materials that might work better. For an hour, he wasn't a cancer patient. He was my friend, the engineer, the guy who understood why this stuff mattered. I'd been so grateful to see him smile that I'd talked for hours, showing him everything, my prototype photos, my cost analysis, my market research, my timeline for filing the full patent. He'd told me it was brilliant, that I was going to change the industry, that he was proud of me. I'd left that night feeling like I'd done something right for once in the nightmare of his treatment. The cancer went into remission 4 months later. Clean scans, good blood work, cautiously optimistic doctors using phrases like very promising and excellent response. We'd celebrated at his favorite barbecue place, him ordering everything he'd been too nauseous to eat for half a year, both of us getting drunk on beer and relief. He'd seemed like himself again, making plans, talking about getting back to work, maybe doing some consulting since his old firm had eliminated his position during his medical leave. He'd mentioned wanting to do something entrepreneurial, something meaningful. I'd encouraged him, told him he had the skills and the perspective now to build something important. He'd asked about my solar panel project, whether I'd filed the patent yet. I'd explained that I was still in the prior art search phase with Douglas, my patent attorney, making sure every element was properly documented and differentiated from existing designs. These things took time. Derek had nodded, said he understood, asked if I'd considered manufacturing partners yet. I told him I was planning to bootstrap the first production run, keep control of the quality. 3 weeks after that dinner, Derek stopped returning my calls. At first, I figured he was busy. People coming out of cancer treatment have a lot to deal with, catching up on life, rebuilding routines. I sent texts, checking in, got brief responses. Doing good, just busy with some projects. Sorry, been swamped, we'll call soon. It didn't feel wrong exactly, just different. We'd been in constant contact for so long that the silence felt strange, but I told myself it was healthy. He was moving on with his life. After everything he'd been through, he deserved to focus on himself. I kept working on my project, sent my completed patent application to Douglas in early August, and started reaching out to potential investors. I'd refinanced my house to fund the first prototype run, had 3 units being built by a local fabricator. The plan was to install them on my own roof and 2 friends' houses, document the installation process and performance data, then use that to pitch to solar installation companies. Then, on September 19th, I got an email from Douglas Reeves at 11:38 p.m., unusual because Doug was a strict 9-to-5 guy who never worked late. The subject line read, "Urgent conflicting patent filing." My stomach dropped before I even opened it. Doug had been doing his routine monitoring of new patent applications in our technology space, something he did weekly to make sure no one was filing conflicting claims that might complicate our application. He'd found something. U.S. Patent Application Serial Number 17/892441, filed August 3rd, titled Modular Solar Panel Mounting Assembly with Novel Load-Bearing Interlocking System. Inventor, Derek Lansing. Doug had attached a PDF of the published application. I opened it with shaking hands. It was my design, every single element. The cam lock mechanism, the specific bracket geometry, the load distribution method, the installation sequence, everything I'd shown Derek in that hospital room and in a dozen conversations after. He'd even used similar language from my notes in the description. But there were just enough changes to make it look original. Different materials specified here, slightly modified measurements there, reworded explanations that meant the same thing. And his application had been filed 6 weeks before mine. I called Doug immediately, didn't care that it was almost midnight. He answered on the first ring, clearly expecting my call. His voice was careful, professional, sympathetic. "I need to ask you something directly, and I need you to be completely honest with me. Did you discuss this invention in detail with Derek Lansing before you came to me?" I told him everything. The hospital visits, the notebooks I'd shown Derek, the specifications I'd shared, every conversation. Doug was quiet for a long time. Then he said, "This is going to be very difficult to prove. Patent law operates on a first-to-file principle now. He filed first. Unless you can demonstrate that he derived the invention from you, that he learned it from you, rather than developing it independently. His patent will likely be granted. Even if you can prove you invented it first, if you disclosed it to him without a non-disclosure agreement, and he filed first, the legal landscape is extremely complicated." I felt the room tilting. What do I do? Doug's answer was measured. "You need to document everything. Every conversation, every sketch, every email, every text message. We need to file an opposition to his patent application, but more importantly, we need to prepare for the possibility that he'll come after you." I spent the next week compiling evidence. I had my original notebooks dating back 18 months, with timestamps and progressive iterations of the design. I had emails to suppliers from a year ago inquiring about components. I had photos of my early prototypes with metadata showing they were taken months before Derek's patent filing. I had text messages to other friends mentioning the project. I had my initial consultation invoice from Douglas Reeves dated 7 months before Derek's filing. The evidence was overwhelming that I'd been working on this long before Derek's application. But Doug warned me that derivative invention claims were notoriously hard to prosecute. We'd need to prove not just that I invented it first, but that Derek's version was substantially derived from my disclosure to him. The legal standard was high. We filed a formal opposition with the patent office, submitted all my documentation, and waited. Doug estimated it could take 6 to 8 months for the patent office to review the conflicting claims. I tried calling Derek probably 50 times over the next 2 weeks. Every call went to voicemail. I sent emails, first confused and hurt, asking what was happening, then angry, then demanding he call me back. Nothing. I finally drove to his apartment on a Sunday morning in early October. His car was in the lot. I knocked on his door for 10 minutes. I could hear movement inside, could see shadows under the door, but he never answered. I stood there feeling like an idiot, like a stalker, talking to a door. "Derek, I know you're in there. I just want to understand. If you needed money, if you needed help, you should have just asked me. This doesn't make sense. We've been friends for 22 years. Just talk to me." Silence. I left a note taped to his door with my phone number, like he didn't already have it memorized, and drove home feeling hollowed out. The betrayal was starting to set in, replacing the confusion. This wasn't a misunderstanding. This wasn't parallel development. He'd stolen my work deliberately, filed the patent in his name, and was now hiding from me. 2 weeks later, the lawsuit arrived. The same manila envelope, a different process server, a much thicker stack of papers. Derek wasn't just defending his fraudulent patent, he was going on offense. His complaint alleged that I had somehow stolen his invention, that I'd been developing it after learning about his concept, and that my continued work on the project constituted patent infringement. He was seeking an immediate injunction to stop me from manufacturing or selling any products, plus damages that his attorney calculated at $840,000 based on projected market value. The audacity of it took my breath away. I sat at my kitchen table reading the complaint, and I actually laughed, one of those involuntary, shocked sounds that comes out when reality becomes absurd. He was accusing me of the exact thing he'd done. The projection was so blatant, it would have been funny if it wasn't destroying my life. My 3 prototype units were being built right now. I'd put $73,000 into development, my entire savings, plus the refinance money. I had meetings scheduled with 2 major solar installation companies in 3 weeks. And now I was facing a federal lawsuit. Douglas Reeves referred me to a litigation attorney named Catherine Holbrook, a partner at a firm that specialized in intellectual property disputes. She had 23 years of experience, had successfully defended numerous patent cases, and had a reputation for being aggressive when her clients were in the right. Our first meeting was on October 29th in her corner office downtown. She was mid-50s, sharp-eyed, and didn't waste time on sympathy. She read through Derek's complaint while I sat across from her desk trying not to fidget. After about 15 minutes, she looked up and said, "This is one of the more brazen cases I've seen. But brazen doesn't mean he won't win. Tell me everything, from the beginning, and don't leave anything out." I walked her through the entire timeline. The friendship, the cancer, the hospital visits, showing him my designs, his remission, his disappearance, the patent filing, everything. She took notes in quick, precise handwriting. When I finished, she asked, "Did you ever send him digital copies of your designs, specifications, or drawings?" I hadn't. I'd only shown him my physical notebook and some photos on my phone. Text messages discussing the invention? A few, but nothing detailed. Any written documentation that he acknowledged learning the invention from you? Nothing explicit. He'd said it was brilliant, that I was going to change the industry, but all of that was verbal or in person. Catherine leaned back in her chair, hands steepled under her chin. "Here's the situation. You have strong evidence that you invented this first. Notebooks, supplier emails, prototype photos, your patent attorney consultations. That establishes priority of invention. What's harder to prove is derivation, or that Derek's patent application was substantially based on what you disclosed to him rather than his own independent development. Patent law requires us to show that he got the inventive concept from you. He'll argue that you two were friends who discussed engineering concepts generally, that he came up with his version independently after those conversations, and that any similarities are either coincidental or because of shared educational background. He'll point to the differences in his design, the material specifications, the modified measurements, as evidence of independent development. The fact that he filed first gives him a presumption of legitimacy. We're fighting uphill." She paused, studying me. "But we have something powerful, the timeline and circumstances. He filed 6 weeks after you told him about it, during a period when he was unemployed and financially desperate after cancer treatment. That's suspicious as hell. And if we can establish a pattern of behavior, if there's any evidence he discussed filing this patent, or tried to develop it in ways that directly reference your disclosures, we can build a circumstantial case for derivation and fraud." The legal strategy Catherine outlined was multi-pronged. First, we'd file a motion to dismiss Derek's complaint as frivolous and improper, arguing that his patent application was fraudulent, and therefore he had no standing to sue me for infringement. Second, we'd accelerate our opposition to his patent with the USPTO, requesting an expedited interference proceeding or derivation proceeding. Third, and this was the part that made my chest tighten, we'd investigate Derek for patent fraud and potentially theft of trade secrets. If we could prove he'd deliberately stolen my invention, it wasn't just a civil matter. It could be federal wire fraud, especially if he'd used email or phone to communicate with the patent office or attorneys. Catherine suggested we hire a private investigator to look into Derek's activities between his remission and the patent filing. "People who do this kind of thing rarely do it in a vacuum," she said. "They talk to other people, they do research, they leave a digital trail. We need to find it." The investigator would cost $8,500 for a comprehensive background workup. Legal fees for the litigation would run at least $150,000 to get through initial motions and discovery. I looked at the numbers on her estimate sheet and felt sick. I'd already spent everything I had on the invention itself. I took out a loan against my 401k, early withdrawal penalties be damned, and hired the investigator. His name was Raymond Keller, former FBI agent with 26 years in white-collar crime before going private. He looked exactly like you'd picture a former Fed, close-cropped gray hair, steady gaze, methodical questions. We met at a coffee shop near my house on November 3rd, and I gave him everything: Derek's full name, date of birth, last known address, employment history, the dates of his cancer treatment, the hospital he'd been treated at, names of mutual friends, social media profiles, everything. Raymond took notes on a yellow legal pad, asked clarifying questions, and then sat back. "The cancer is interesting," he said. "People who've been through serious illness sometimes develop a survivalist mentality, a feeling that they're owed something, that normal rules don't apply because they've already faced the ultimate unfairness. Not saying that's what happened here, but I've seen it before. Financial desperation plus moral permission equals crime." He asked if Derek had any business partners or family members who might be involved. Derek's parents were retired in Florida. His younger sister lived overseas. Neither seemed likely to be part of this. He'd been single during his treatment, no girlfriend that I knew of. Raymond said he'd start with Derek's digital footprint, social media activity, any public records, and see what patterns emerged. While Raymond worked his investigation, Catherine and I prepared our legal response. We filed a comprehensive answer to Derek's complaint, denying all allegations and counterclaiming for a declaratory judgment that his patent was fraudulent and unenforceable. We submitted my entire evidence file, every notebook page, every email, every photo, all properly authenticated with metadata analysis. We included a detailed timeline showing that I'd been developing this invention for 18 months before even mentioning it to Derek, and that his patent application came just 6 weeks after I'd disclosed the complete design to him during his hospital stay. We requested expedited discovery, asking for Derek's complete communications history, bank records, any notes or files related to his patent development, and depositions of anyone he'd discussed the invention with. Catherine was thorough and aggressive. "We're going to make this hurt for him," she said. "If he's smart, he'll realize this is a losing battle and withdraw the patent application and the lawsuit. If he's not smart, we'll destroy him in court. Either way, you're getting your invention back." Derek's attorney was a solo practitioner named Gerald Finch, who operated out of a converted house near the courthouse. Catherine knew him by reputation. Competent, but not exceptional. Usually handles small business disputes and contract work, not really an IP specialist. That told us something about Derek's resources. If he'd had serious money, he'd have hired a big firm. Either he was betting on a quick settlement, or he was in over his head financially and couldn't afford better representation. Gerald's initial responses to our motions were defensive and template-based, the kind of filings you can tell were adapted from other cases without much customization. He argued that Derek had independently developed his invention, that the similarities to my design were superficial and inevitable, given the limited approaches to solving the same technical problem, and that Derek's earlier filing date gave him presumptive priority. He provided no documentation of Derek's development process, no notebooks, no sketches, no emails, no prior art research. Just the patent application itself, and a declaration from Derek stating he'd begun working on the project in early 2023 without any specifics. Raymond Keller called me on November 16th with his first report. He'd been through Derek's social media, public records, and had interviewed 3 people who knew Derek, carefully, without revealing why he was asking. The picture that emerged was troubling. Derek had been in serious financial trouble during and after his treatment. His medical bills, even with insurance, had been catastrophic, over $200,000 in out-of-pocket costs. He'd maxed out credit cards, taken personal loans from family members, and had apparently been applying for business loans in the months after his remission. Multiple loan applications, all rejected due to lack of collateral and weak business plans. Guy was desperate, Raymond said, and there's something else. He started following a bunch of business influencer types on social media right around the time you told him about your invention. The kind of people who post about capturing value and being strategic about information. One guy in particular, username PatentHacker3000, posts all about finding valuable ideas and filing provisional patents before other people do. Derek liked and commented on about a dozen of his posts in July and August. Raymond sent me screenshots. They were chilling. Derek commenting on a post about the value of being the first to file, with "needed to hear this today." Another comment on a post about protecting yourself in competitive markets, with "game recognizes game." The social media activity gave us a window into Derek's mindset, but it wasn't enough for a fraud case. We needed something more direct, evidence that he'd specifically referenced my invention in his preparation for filing. That came through discovery. In mid-December, after weeks of legal wrangling, Judge Franklin Monroe ordered Derek to produce all documents related to his development of the solar panel mounting system. Derek's attorney provided a flash drive with about 24 files, mostly his patent application drafts, and some generic research articles about solar energy markets. Catherine reviewed them first, then called me into her office looking like a cat that had spotted a mouse. "He's either very stupid or very arrogant," she said, turning her laptop toward me. "Look at the metadata on these files." The earliest document in Derek's production was dated July 28th, 5 days after my detailed hospital room disclosure to him. There was nothing before that date. No earlier drafts, no preliminary sketches, no research. Just a sudden appearance of a fully formed invention concept the week after I'd shown him mine. Even more damning, several of his patent application draft files had embedded comments and change tracking that he'd forgotten to remove. One comment in his own username read, "Change terminology here to avoid direct similarity to M's description." M was me. My first name started with M, so Catherine had the file analyzed by a computer forensics expert named Laura Simmons, who confirmed the metadata was authentic and unaltered. The documents showed a clear timeline. Nothing before late July, then sudden intensive work on a patent application in August, with multiple references and comments to changing language to avoid detection. Laura found something else. Several of the technical drawings in Derek's patent application had been created using measurement units that matched my notebook sketches exactly, then converted to slightly different numbers. "He traced your designs," Laura explained, "then changed the dimensions by 5 to 10%. You can see it in the image file data. The original layer has your measurements, then there's an adjustment layer with the modified numbers." It was smoking gun evidence that Derek had started with my designs and altered them just enough to claim they were different. Catherine filed an emergency motion with the court, attaching all the forensic evidence and moving for immediate dismissal of Derek's complaint and sanctions for fraud upon the court. We also referred the matter to the USPTO's Office of Enrollment and Discipline, requesting investigation of Derek's patent attorney for knowingly filing a fraudulent application. Judge Monroe scheduled an emergency hearing for January 8th. The morning of the hearing, I sat in Catherine's office reviewing our presentation. We had 3 binders of evidence, organized with color-coded tabs: green for my original development timeline, red for Derek's theft indicators, blue for the forensic analysis. Catherine was calm and focused in that way really good trial attorneys are, moving through the exhibits with practiced precision. The judge is going to ask Derek to explain the metadata, the comments, and the forensic findings, she said. He's going to have two options. Admit he used your designs, or claim the evidence is somehow fabricated or misinterpreted. If he goes with option 2, we'll ask for an in-camera review of his personal computers and phones. He won't want that. We walked to the courthouse through cold January rain, carrying our evidence binders in a wheeled case. Derek was already in the courtroom with Gerald Finch when we arrived. It was the first time I'd seen him in person since the lawsuit started. He looked thin, whether from the cancer after effects or stress, I couldn't tell. He wouldn't make eye contact. He sat rigidly next to his attorney, staring at the table in front of him. Judge Monroe was a federal district court judge with 30 years on the bench, known for not tolerating nonsense and moving cases efficiently. She came out at exactly 10 a.m., and everyone stood. She sat, we sat, and she got right to it. Mr. Finch, I've reviewed the forensic evidence submitted by the defense. I need you to explain to me how your client's patent application documents contain metadata dating to after the plaintiff showed him these designs, and contain comments specifically referencing modifying language to avoid similarity to another person's descriptions. Gerald Finch stood, cleared his throat, and attempted a response about standard patent drafting practices and common terminology in the field. Judge Monroe cut him off. Counsel, I'm not asking about terminology. I'm asking about the comment that reads, change terminology here to avoid direct similarity to M's description. Who is M? Finch glanced at Derek, who had gone very pale. Your Honor, that was simply a reference to market descriptions, not any specific person. Judge Monroe looked over her reading glasses. Market descriptions, abbreviated as a capital M, in a personal comment field on a patent application draft. She let the silence hang. Mr. Finch, I'm giving you one opportunity to reconsider your client's position. Does your client wish to withdraw this lawsuit? Gerald Finch requested a brief recess to consult with his client. Judge Monroe granted 10 minutes. Catherine and I sat quietly, while Derek and Finch huddled in whispered conversation in the hallway outside. Through the courtroom windows, I could see Derek gesturing, agitated, Finch shaking his head repeatedly. They came back in, and Finch approached the bench. Your Honor, my client maintains that his patent application was independently developed. However, in light of some confusion regarding file metadata, he's willing to dismiss his complaint without prejudice and withdraw his patent application. Catherine stood immediately. Your Honor, the defense objects to dismissal without prejudice. Mr. Lansing has put my client through 4 months of litigation based on what the evidence clearly shows is a fraudulent patent claim and frivolous lawsuit. We request dismissal with prejudice and an award of attorney's fees and costs. Judge Monroe nodded slowly. I'm inclined to agree with the defense. Mr. Finch, your client filed a lawsuit claiming infringement on a patent that the evidence strongly suggests he derived from the defendant after the defendant disclosed the invention to him during a period of personal crisis. This isn't just a failed case. This appears to be litigation misconduct. What happened next was one of those moments where everything pivots. Derek suddenly stood up, interrupting his own attorney. I'd like to make a statement to the court. Judge Monroe looked surprised, but nodded. You may speak, Mr. Lansing, but I advise you to be very careful. Anything you say is on the record. Derek's voice was shaking. I did use his designs. He showed me everything in the hospital, and I took notes on my phone. I was going to die, or I thought I was, and when I survived, I felt like I deserved something for what I'd been through. He had this brilliant idea, and he was just sitting on it, moving so slow, and I thought if I filed first, I could build something, make some money, get out of debt. I wasn't thinking straight. The medical bills were crushing me. My family had given me everything they had. I needed a way out. The courtroom was dead silent. Gerald Finch had his head in his hands. Catherine sat perfectly still, letting Derek talk. Judge Monroe's expression was unreadable. Derek kept going. I changed just enough to make it look different, but it was his invention. All of it. I'm sorry. I'm so sorry. I couldn't see another way. Judge Monroe let the silence extend for a long moment after Derek stopped talking. Then she said, Mr. Lansing, I appreciate your honesty now, though it would have been more appropriate before filing a federal lawsuit. Here is my ruling. The plaintiff's complaint is dismissed with prejudice. The plaintiff's patent application, serial number 17/892-441, is hereby declared fraudulent and unenforceable. The defendant is awarded full attorney's fees and costs. Additionally, I am referring this matter to the U.S. Attorney's Office for investigation of possible federal wire fraud and false statements to the USPTO. She looked directly at Derek. What you did isn't just civil misconduct, Mr. Lansing. Filing false documents with a federal agency is a crime. You will likely face criminal investigation. You should obtain criminal defense counsel immediately. She banged the gavel, and it was over. Derek sat down heavily, and I saw tears on his face. Part of me felt vindicated. Part of me felt sick. This was my best friend since childhood, the guy I'd helped through cancer, and he'd just admitted in open court to stealing from me because I'd been too trusting to protect myself. The courtroom cleared slowly. Catherine and I packed up our exhibit binders while across the room, Gerald Finch was having what looked like a very difficult conversation with Derek. Catherine turned to me once we were in the hallway. That was as close to a perfect outcome as you could hope for. His admission is binding. His patent is dead. You'll get your legal fees reimbursed, and you can proceed with your patent application without interference. The criminal referral is the judge's discretion. It may or may not result in charges, but even the investigation will be punishment enough. I nodded, trying to process it all. What happens to him now? Catherine shrugged slightly. He'll be investigated by the U.S. attorney. If they decide to prosecute, he could face fines and potentially prison time for wire fraud, though first-time offenders in white-collar cases often get probation and restitution. His bigger problem is the patent bar. He'll likely be banned from filing patents, which given his engineering background is career-limiting. And you could sue him civilly for damages, though given his financial situation, you'd probably never collect. I thought about it. I don't want to sue him. I just want my invention back. Catherine smiled slightly. Then you're a better person than most. Let's get you back to building your business. The U.S. Attorney's Office investigation moved slowly. I gave a statement to Assistant U.S. Attorney Jennifer Ochoa in late February, walking her through the timeline and providing copies of all the evidence. Jennifer was methodical and thorough, asking detailed questions about Derek's statements to me in the hospital, the social media activity, the metadata findings. She told me they were also looking into whether Derek's patent attorney had knowingly participated in the fraud. If so, that attorney would face disbarment and potentially criminal charges as well. In early April, Derek was indicted on 2 counts of wire fraud and 1 count of making false statements to a federal agency. The indictment alleged that he'd used interstate communications, email and phone, to file a fraudulent patent application with the USPTO and had made false statements in his patent declarations about being the original inventor. Maximum penalty was 20 years on the fraud counts, though actual sentencing would be far less. Derek pled guilty in June to 1 count of wire fraud in exchange for the other charges being dropped. Sentencing was scheduled for September. While the criminal case proceeded, I got my life back on track. My patent application was approved in August, U.S. patent number 11,654,203, modular solar panel mounting assembly with novel load-bearing interlocking system. Inventor listed as just me. I'd used the settlement money from the fee award to pay off my loans and fund the first production run. By the time Derek's sentencing hearing arrived in September, I had 12 functioning units installed on customer properties, contracts with 3 solar installation companies, and actual revenue coming in. The business was working. The invention I'd spent years developing was finally doing what it was supposed to do. Catherine called me the morning of Derek's sentencing to see if I wanted to attend the hearing. I thought about it for a long time. Part of me wanted to see the conclusion, wanted to face him one more time. Part of me wanted to just let it go. I decided to go. The sentencing hearing was in the same courthouse, different room. Derek looked smaller than I remembered, wearing a suit that didn't quite fit, standing next to his new attorney, a public defender named Marcus Chen who specialized in white-collar sentencing. The courtroom was nearly empty, just a few journalists and Derek's parents in the back row. His mother was crying quietly. Judge Monroe presided again. She reviewed the presentencing report, which detailed Derek's cancer treatment, his financial desperation, his lack of prior criminal history. She listened to Marcus Chen's plea for leniency, emphasizing Derek's remorse and his struggles with medical debt. Then she asked if I wanted to make a victim impact statement. Catherine had prepared one, but I hadn't decided whether to deliver it. Standing there, looking at Derek's hunched shoulders and his parents' devastated faces, I made a choice. I stood up and said, "I'd like to speak." Judge Monroe nodded. I walked to the podium, and for the first time since the initial lawsuit, Derek looked directly at me. I'd planned to talk about the betrayal, the financial damage, the emotional toll. Instead, I said this. Your Honor, Derek and I were best friends for 22 years. I was with him through the worst time of his life, and I'd have done anything to help him survive it. When he got desperate after his treatment, he could have asked me for money, for help, for anything. I would have given it to him. Instead, he stole from me, lied to federal authorities, and put me through 4 months of hell. What he did was wrong, and it deserves consequences. But I also know that the cancer and the debt did something to him, broke something in how he saw the world. I'm not asking for mercy. That's the court's decision. I'm just saying that the person who did this isn't the complete picture of who Derek was. I hope when this is over, he finds a way to put himself back together. I sat down. Derek was crying openly now. Judge Monroe thanked me and said she'd considered everything carefully. She sentenced Derek to 18 months in federal prison, 3 years supervised release, and $127,000 in restitution, the amount of my legal fees and costs. It was a substantial sentence, but far less than it could have been. I left the courthouse and didn't look back. Over the following months, my business grew steadily. I hired 2 employees, moved out of my garage into a small industrial space, and started shipping units to customers across 3 states. Industry publications ran features about the innovative mounting system, and I did a few podcast interviews about the technology. Derek's name never came up. I didn't mention the lawsuit or the theft in any public setting. It was my invention, my business, and the past stayed in the past. I heard through mutual friends that Derek had reported to federal prison in November to serve his sentence. His parents had sold their house to help him pay the restitution. He'd be eligible for early release after 12 months with good behavior. I didn't know if we'd ever speak again. Maybe someday, after enough time had passed, after enough healing. Or maybe the friendship was one of the casualties, something the cancer and the desperation had killed just as surely as it had tried to kill him. 10 months later, I got a letter forwarded through Catherine's office. It was from Derek, written on prison stationery in his familiar handwriting. It was 3 pages long, and I almost didn't read it. I set it aside for 2 days, unsure if I wanted to reopen everything. Finally, late one evening after a long day of installations, I sat down and read it. The letter was a full accounting, an apology that didn't make excuses but tried to explain. He described the mental state he'd been in after remission, the terror that the cancer would come back, the suffocating weight of the debt, the feeling that the universe owed him something after taking so much. He wrote about the moment he'd first thought about filing the patent in his own name, how he'd rationalized it as just getting there first, with an idea we'd developed together. How that rationalization had grown until he'd convinced himself it was somehow fair. He wrote about the guilt that had eaten at him every day, but that he'd pushed down because he couldn't see another way out. He wrote that he'd known it was wrong and had done it anyway, and that he'd have to live with that forever. The last paragraph stayed with me. You said in court that cancer broke something in how I saw the world, and you were right. It made me think everything was about survival, that morality was a luxury I couldn't afford. I was wrong. I'm sorry doesn't fix what I did to you, and I don't expect forgiveness. But I want you to know that I'm using this time to try to fix what broke in me. I'm working with a therapist here, dealing with the PTSD from the cancer treatment that I never addressed. I'm learning that survival isn't the same as living, and that becoming a person who would betray his best friend means I didn't really survive after all. Thank you for the statement you made at sentencing. You didn't have to say anything decent about me, and you did anyway. That's who you always were, someone who helped, even when it wasn't deserved. I hope someday, maybe years from now, I can show you that I'm working to become someone who deserves that kind of friendship again, even if it's too late for us. I read the letter twice, then folded it and put it in my desk drawer. I didn't write back, not then. Maybe someday. For now, I had a business to build, employees to support, customers to serve. The invention I'd dreamed up in my garage, refined through countless iterations, nearly lost to betrayal, was out in the world doing exactly what I'd designed it to do. That felt like enough justice. The rest, the friendship, the forgiveness, the healing, that was something time would have to work out on its own. I went back to my prototypes, my installations, my plans for expansion. The solar panels gleamed on rooftops across the city, secured by brackets that bore my patent number, generating clean energy and proving that sometimes, even when people try to steal your future, the truth finds a way to shine through. If you enjoyed this, you'll definitely want to see the next ones too. So subscribe now and let me know your take in the comments.